So this series of workshops on international environmental law that Youth Environment Europe is organizing is part of the Legal Seeds projects, which aims to building capacity and raising awareness on environmental law in order to create opportunities for young people, even if you're not familiar with law, to increase your understanding on these issues and on the tools of environmental law. This will be the first of a series that aims indeed to build capacities and increase your knowledge on international environmental law. And hopefully by the end, you will actually become more aware, and you will be more familiar and be able to use the environmental law tools by yourself as well. I remind that all the workshops are recorded during the main sessions. And at the end of, if you participate to 75% of the workshops, you will receive a certificate. So we are really looking forward to see you from now on throughout the whole series of workshops. The subject of this specific workshop is international environmental law and its basics. We wanted to start by explaining and sharing which are the principles of international environmental law and the main international conventions and declarations. The structure of today's workshop will be, if you can kindly change slides, please. Okay, will be, first of all, we will cover the basic principle of international law. Following, we thought that we would divide it into groups, and make a SWOT analysis, which is like an analysis of the strengths, weaknesses, opportunities, and threats related to each of the one of the four initial principles that we will present. Afterwards, we will also present the international conventions, the main international conventions on environmental law. And then at the end of it, you will have the chance to put what you have learned during this workshop into practice through an exercise. This is the main structure. If you have any question regarding it before we start, please do it now. And if you have any question throughout the whole session, please ask the questions on the chat, and at the end we will have plenty of time to answer them as well. So I'm not able to see any question. I think that I will pass then the floor to Agnes, that will introduce the basic principles of international environmental law. Please.
Thank you so much, Emma, for the brief overview of the agenda that we will follow today. Before doing that, I would like, as we are all here and I have your interest right now and your attention, I would like to, we will send you through email the whole work that we have done from the entire project that we started in October. We have already a handbook on EU environmental law and a lot of articles published in different topics like the right to healthy environment, climate litigation, public participation, and other topics more specific. Now we're on the making of another handbook on public participation, and the workshops themselves, they're also included in the project, and we are also we will include experts in the next workshops, especially to the ones that they concern climate litigation. So that's a brief overview of what we have already done. You will receive an email with details and access to the publications, because we really think that it's very important for young people to get access more to law. So going from saying this, yeah, we think that it's very important first to understand what is international environmental law. So international environmental law is a branch of international law in general, and it has been created in order to offer protection on different environmental aspects. It has begun, we will examine the international conventions and how they developed from the beginning till now. So what is very important to understand in international environmental law, its basic principles, its core, in order to be able to navigate through the tools that they are offered to international environmental law. So the most important, we have gathered the most important ones, and the first one that we're gonna see, it's the no harm rule, which is actually what it is the main responsibility of states not to cause environmental damage to another state. So this is usually how it happens, is that a state cannot do some activities that they will cause, for example, air pollution or water pollution to another state. It has to comply with this no harm rule. Also, it has the obligation through this rule of due diligence, and it needs to take all the essential measures to avoid the damage. And if this happens and the damage still occurs, then the principle is not violated. So here, it's something that you will need probably for the exercise later, as I will explain to you. But we can see a limitation here of the principle that the state needs to take all the essential measures, but if it does, and then the environmental damage happens, then there's no violation. So here we can see a bit of a controversial issue. The main limitation, also it's the main limitation to the principle of permanent sovereignty of natural resources. What does this principle mean? When we say the principle of permanent sovereignty of natural resources, it means that every state has the ability to extract or use or not use its natural resources as it wants. So the no harm rule, it means that the exploitation of natural resources is limited by the duty not to cause significant damage to the other states. So it can use them, it can extract them or not, but only if it doesn't cause environmental damage to a neighboring state, or if it's a state across the other side of the world. This principle was enshrined in the 21st principle of Stockholm Declaration, which is a declaration that we will speak later about it. So this is the first one we will examine, and this will also be included in the exercise that you will be called to do later. The next principle is the principle of prevention. It's a proactive principle. It's the general duty to proactively take measures. So it's to prevent environmental damages. So it's a procedural extension of the duty to cooperation. States need to cooperate in order to prevent, not to cause environmental damage. It's also a requirement to conduct an environmental impact assessment where the proposed activity is likely to have a significant adverse impact. So, for example, if there is a plan of either building a coal-fired plant, for example, that would be 30 years ago, then it would be necessary to have an environmental impact assessment. But this is also a requirement for renewable projects. So this is always a requirement in order to see what is the damage that might be caused and to take measures before doing this activity in order to prevent and cooperate with the other states in order to prevent environmental damage. This was also enshrined in the 21st principle of Stockholm Declaration. Another principle is the principle of precaution, which means to take appropriate measures when effects that may be irreversible will be caused. And the important thing with this principle is that even there will be lack of scientific certainty on the effects that an act can have, an action, then this shouldn't prevent the states to take these measures. So states cannot claim that, okay, now I'm not aware that this might not cause environmental damage, so I'm not going to do anything. So this is a more, it limits the action of the states, and it doesn't give them a lot of space to justify their actions. This was enshrined in the Article 3 of the UNFCCC, which we will discuss about later. And the European Court of Justice recognized this principle as normative bonus of the precautionary principle that we saw, as general principle of EU law, which means that it became part of the general principle of EU law, and now it can be used in the court. So another one is the polluter pays principle, which is very popular. I think most of you have already heard of it. Its aim is to ensure that the financial burden of pollution is done by those who cause it. So it is actually what it says, that the polluter needs to pay for the pollution that they're causing. The concept is to internalize the negative externalities. And what does that mean? It means that when from an activity, for example, from a factory or a company, that it's done, they need to pay for the pollution that they're causing. And the negative externalities is that they're externalizing the pollution, so they need to internalize it by paying for it. This principle was enshrined in the Principle 16 of Rio Declaration, and the what is actually promoted and what is actually advised for the public bodies is that national authorities should promote mechanisms to guarantee the internalization of environmental costs, and that the polluter actually pays the cost of pollution in order to keep a balance and make the carbon majors, the ones that are affecting the most the environment, to pay for it. So another principle is the principle of CBDR. What does that mean? It's the principle of common but differentiated responsibilities. It's a principle that has been discussed a lot lately, and especially in the latest COP and in Glasgow. It aims to distribute the efforts that they require to manage environmental problems of global nature among states, and it divides the countries in developed and developing countries. So that was the first category, that it was that countries were divided, developed and developing, and then another criteria was set, that it's about the historical responsibility and the respective capabilities, financial or technical, they have. So what this does actually means is that states are held accountable for to pay and to contribute to the combat against climate change, depending on how much they can contribute and what is their responsibility. So this is a very important principle, and that's why it's a huge discussion, because usually what happens is that the ones who are polluting the most are not the ones who are experiencing also the environmental damage, and they're not paying. So this is why it's a huge discussion, because you cannot ask for the same contribution from a country, for example, the Netherlands, that have the capability to pay and to contribute in the combat towards climate change, with a developing country that can't do that. So this principle was enshrined in Principle 7 of Rio Declaration, and this shows the common dimension of the principle of the duty of cooperation, which is, we can imagine this as an umbrella principle, the duty of cooperation among the states, in a spirit of global partnership in order to protect the environment. But also it recognizes the different dimension of the treatment that they need to have, the states, according to their abilities to combat climate change. So now after seeing the principles and having some of them in mind, I will also have the slides available if anyone wants to ask anything when we are doing the group work. So what is going to happen here is like we're going to divide you in 4 groups, and you will analyze, and we will also be with you, the strength, weaknesses, opportunities, and threats of the below principles: the no harm principle, the prevention principle, the polluter pays principle, and the principle of common but differentiated responsibilities. So as you have seen, some of them, they have strong strengths that they can protect and they can prevent the environmental damage, but they also have some limitations, which is the weaknesses. And what are the opportunities and threats? For example, if you were advising the state on how should it act, what are the opportunities that this principle that you will be allocated to work on has and offers regarding environmental policy, and what are the threats that you should take into consideration for this principle. So
I think we've got everyone back. So Emma, over to you again.
Yes, so welcome back to the main session. I hope you found the analysis useful to apply what we were like presenting before, and I hope you had a little bit of discussion about which are the strengths or weaknesses of the principle you were given. Is there anybody who wants to share what some thoughts or some ideas you came into, or should we go group by group? For example, if there is one, I was in breakout room 1 before, if you came up with some analysis on the no harm principle.
Yeah, we have everything actually. So strength, we were thinking that it talks about something clear and well defined, in the sense that it's like we know what environmental damage is. So for example, there are other principles, like for example the common but differentiated responsibilities, that in itself it's a bit more debated, whereas the fact that you should not create damage to someone else is more, at least we have the impression, because we actually don't really know in practice, but we think it's a bit easier to accept as a principle in itself. It's less debatable. And then a weakness, we were thinking 2 weaknesses. The first one is the fact that it is difficult, it can be difficult to prove the damage in itself, to establish responsibility. And at the same time, there is, but this is an underlying issue, of course, of international law in general, and that's the issue of state sovereignty. And so how effective can this principle be in limiting the sovereign will of a state? And then with respect to opportunities, we were thinking that the fact that the ever-increasing development of environmental sciences might in the future make it easier and easier to identify and prevent damage. And finally, with respect to threats, we were thinking that power imbalances over countries might make it hard to implement this principle, because the countries that receive the damage, let's say if it's economically dependent on the country that makes the damage, might be disincentivized from actually pursuing the respect of this principle.
That sounds to me a quite complete analysis. Laura, Agnes, do you have something to comment on this, or particular? Because for me, it looks a very complete analysis, and I hope like you had also clear idea on how to approach this principle as well.
I really like the threat approach, to be honest, the imbalances among countries. I found it very innovative. And that one. So I don't want to waste more time on my comments. So
No, me neither.
Yes.
It would be great to hear from the next group, I think,
On the group 2, is there anybody willing to share your findings?
Hi. So basically we had the prevention principle. For strengths, we identified that it prevents from further pollution, both of which that we may know or we may not know about or be aware of. And we also said that it encourages cooperation, which is important within the transboundary context of environmental law. For weaknesses, we identify that if there are any damages, states may not be penalized due to the principle not being legally binding, and that it falls under the context of soft law, and it is therefore more of a guideline or recommendation. For opportunities, we said that pertaining to environmental impact assessments, these may assess impacts prior to project initiation, which is also a strength, and thus negating the project if risk is observed or if there's the belief that risk may occur. And finally, for threats, we said with respect to environmental impact assessments, not all factors are taken into consideration. And we also mentioned that there is a lack of available data prior to environmental impact assessment initiation.
Thank you so much. Also, another very complete analysis, and thank you a lot for sharing. Thanks very much. Is there anybody for group 3 that wants to share?
So group 3, we had like the polluters and pays principle. So for considering the strengths, we put like the strength can be like to point out the country responsible for the pollution. I can prevent countries and companies from polluting, and for individuals, it creates also a shared responsibility to take care of the environment. As for the weaknesses, we put that it's hard to point out one polluters, specifically when it's like, for example, like pollution that are ambient, like air pollution. How can we put a price on the consequences? It de-emphasizes the implication of the country, and also it's difficult to ensure follow-up on such principle. Is specifically it's if it's international rather than national principle. And so like the general weakness or threat on accountability or payment. As for the opportunities, we put I can develop more accurate mechanisms, and it can also help developing extended producer responsibility schemes. And for threats, we put that some companies will put their responsibility on individuals.
Thank you so much to group 3 as well. Finally, is there someone from group 4 that wants to share about the last principle?
I can do it if no one else is. Yeah. Okay. So for the common but differentiated responsibilities as a strength, we found the fact that it's a principle that brings ethical arguments on the scene. So it takes into account, like intergenerational equity, because it takes into account like the past and colonization, basically, and also like environmental justice and the fact that some countries are not equal between us, and some that are not like equally responsible. So it takes fairness into account. It also supports global action because it recognizes that it's not only like each sovereign state has I can do whatever I want on my territory and blah blah blah, but it also like recognizes that there's a need for common and global and concerted action. Basically, then in weaknesses, we found, well, I mean, that's a general argument for international law, but that it only relies on the goodwill of countries, and indeed, like even richer countries, because like they are supposed to give means and like financial support and expertise support to less developed countries, but then it only like depends on their goodwill. Then on opportunities, we found that it supports the transfer of financial means and expertise and technologies, and it supports the fact like it could be operationalized to quantify like how many like carbon dioxide each country should lessen, or like what countries should do what. It can be the basis of a real quantification to know that. And it kind of did, because it support like in the COP processes. This principle supported the creation of a climate fund, for instance. But then again, in the threats, it's always like it's actually hard to operationalize, and it's only depending on the goodwill of countries. And also we found finally as threats that that principle can also serve as a kind of excuse for developing countries, in the kind of discourse like, oh, but you industrialized countries, you developed sharing CO2 and blah, blah, blah. So we can do the same. And so we don't have to find a more sustainable development path. So it can kind of also be an impediment for developing countries to be more sustainable, especially with like in between cases like China, for instance, who were industrialized later. So they sometimes think that, they argue that they don't have responsibilities, but now we know how like the system of China can pollute. So yeah, that was it.
And thank you a lot also to Group 4 for this, for sharing this. Also the last complete analysis as well. I don't know if Agnes or Laura have any comment on this. Otherwise, we can just go over the next session. This analysis you have just made will definitely be useful for next session on international conventions. I had some questions on the breakout room 1 before, and your questions will be answered in this part. So I will pass the floor back to Agnes, that will explain to you the main international conventions and declaration on international environmental law.
Thank you so much, Emma. Thank you everyone for participating on this exercise. I hope that now you have a better understanding of the basic principles of international environmental law. And now it's time to jump on the development of international environmental law and how this happened through the conventions. So I'm gonna share my screen, and here we can see the conventions that we're gonna discuss. It's the UN Stockholm Declaration, the Rio Declaration, the Paris Agreement, the ESPO Convention, the United Nations Framework for Climate Change, and the Aarhus Convention that Laura is going to speak for it. So we begin like in early 1972, which is, for me, it was very impressive when I found out that this discussion started so early. The climate change discussion in Stockholm, which was the first actual conference regarding environmental issues. And many states gathered in order to discuss how the issue of climate change has to be handled. And the main outcomes of the conference were there were policy outcomes as the Stockholm Declaration and an action plan for the human environment, which is the most actually the most innovative thing that you need to remember from the Stockholm Declaration is that there was an institutional innovation, and the United Nations Environmental Program, the UNEP, the central body which is in charge of environmental affairs today, was created through this declaration. And also it was the first international document to recognize the right to a healthy environment. So after that, 20 years later, Rio Declaration took place in 1992. Also, I have to mention that these declarations are not legally binding. They are considered soft law. So the policy outcomes of the Rio Declaration on Environment and Development, the main were that there were principles regarding forests. The concept of sustainable development was actually discussed and formed in the Rio Declaration, which is something that now we have been hearing a lot, and how we can combine economical growth while respecting and protecting the environment. And there was expectations created, but again, not something legally binding, that states will enact in environmental legislation, as it was actually, it was a bit repeating what it was discussed in Stockholm, but with a more with some more concrete outcomes. Also, the polluter pays principle was first mentioned in the Rio Declaration, and then it developed more and more throughout the years. The main outcomes of the Rio Declaration were two conventions, the Convention on Biological Diversity and the United Nations Framework Convention on Climate Change, which is very important, as we will see later on. So the United Nations Framework Convention on Climate Change in 1992, it's an international environmental treaty which aims to address the issue of climate change and to stabilize the greenhouse gas emissions in the atmosphere. It was signed by 154 states at the UN Conference on Environment and Development, and it is known as Earth Summit. So in case you might have seen it as the Earth Summit. It was first implemented by Kyoto Protocol, and then it is considered the mother convention for the Paris Agreement, which is the most known, I think, among everyone here, the Paris Agreement. Also, it's very important to note here that the supreme decision-making body of this treaty is the known COP, the Conference of the Parties, which meets annually to assess the progress regarding climate change. And the next one, COP27, is going to happen in Egypt in November. So it has also divided the countries in developed and developing, and therefore, as you have seen, and now you can understand, the common but differentiated responsibilities concept and principle was started to becoming an issue from there, and then it was developed in the Kyoto Protocol, and then it was developed more and more in the actual form that we have now after the Paris Agreement. But as you have spotted in the weaknesses of this principle, it's still very debatable. So after that, the ESPO Convention took place in 1997, and it's a convention on environmental impact assessment in a transboundary context. It's a United Nations Economic Commission for Europe convention signed in Espoo in Finland, if I'm not mistaken. And the main obligations that derive from this convention is the environmental impact assessment, which happens in early stages of planning, especially for infrastructure projects. And member states need to notify and consult each other on all major projects under consideration that they're likely to have significant adverse environmental impacts, even if it's outside of their territory. So here we also see the role of duty of cooperation among states. So here we are in one of the most famous, we would say, international environmental conventions is the Paris Agreement, which happened in 2015. And its goal is to limit the temperature increase to 1.5 degrees Celsius degrees, and in any case below 2 degrees, and to stabilize the increase of global average temperature. Also, it's very important to note here that it promotes, it sets actually as a goal to promote financial flows towards low carbon greenhouse gas emissions, which is very important for every state to take into consideration. And here you can see that also the principle of common but differentiated responsibilities has been applied and discussed and has been transformed, not from developed and developing countries, but regarding their historic responsibilities and their respective capabilities. What we have to know about the Paris Agreement is that there wasn't enough mention about renewable energy projects, but the fact that it is trying to counter other technologies and to promote the financial flows toward low carbon options. That's how it's interpreted, that it's trying to promote a shift towards renewables. So now it's time for Laura to take on the floor.
Yes, thank you, Agnes. I'll just briefly add on one other convention. It's got a very long name, but most of you might know it as the Aarhus Convention because it's named after the place in Denmark where it was agreed. But it's the Convention on Access to Information, Public Participation in Decision-Making and Access to Justice in Environmental Matters. And it sets out what is often called key environmental democracy rights, so rights of the public essentially to contribute and to challenge environmental decision-making. And I've put down a quote from the objectives because I think it's quite interesting, especially from a young people's perspective, that it makes direct references to present and future generations and has in its objective integrated the angle that these environmental democracy rights serve as a means to an end to help current and future generations to live in an environment adequate to their health and well-being, and that those environmental democracy rights are therefore seen as a sort of means to an end to achieve that. And Agnes, if you could go to the next slide, please. There are often what's called we often talk about 3 pillars of the Aarhus Convention, and this graph tries to visualize the 3. So there are rights on access to information, public participation, and access to justice. And we'll come back to public participation in a future workshop. So maybe just 1 minute on each of the other 2. So the right on access to information is also sort of a twofold right that parties to the convention both have to directly provide certain types of information. So without you needing to ask for them, they just have to be made publicly available to you. But then it also entails an opportunity to request certain types of information from the member state. So you can ask them to publish certain information on certain pollutants or something from an industry around the corner from your home, for example. And then the third one is access to justice, which means that you have opportunities to challenge environmental decisions and to challenge whether they are compatible with other, for example, international agreements or national legislation, and that you have an opportunity to basically be heard in court or through another decision, through another body that enables you to have a review of certain legislation and or certain decisions, sorry, not just legislation. And yeah, public participation, as I said, we'll come back to, but that's also a key principle to enable citizens and NGOs more broadly to enable to participate in decision-making processes to ensure that environmental obligations are also complied with. But I would leave it here for now, as we're also a bit low on time. And I think Emma is next to introduce us to another exercise for you to do to see how you can apply those conventions through a case example. Emma?
Yes, sure. Thanks, Agnes and Laura, for the presentation. Now we're going to case exercise. So as you see here, I will briefly read it in a way. You will be asked to read this case, and which is the following. I will read now. The Kingdom of Ashkar, signatory party of a given convention, hasn't changed its climate policy regarding the use of coal since 2010. Even though the government was promising to shift almost entirely to renewable energy, the energy crisis that occurred made it change its plan, and it will continue finances the use of coal. So the coal power plant are emitting a certain amount of greenhouse gas emissions, which is way above the average level allowed. Additionally, wind farms are going to be established in a specific area where there are unique species of birds and flowers. Even though there is enough space to establish wind farms in other areas which aren't of such high environmental value, the project is about to begin soon. So this is the scenario. Like in this given scenario, you're asked to, as a citizen of that state, to like which are the steps that you would follow in order to take action against this measure, against this action from the state. So we suggest to go through the conventions and declaration that Agnes and Laura have just explained, and you explain which, in your opinion, you would use in order to exercise and some rights and your rights and like protect the environment. So here we also have some guiding questions. Which conventions would you apply in this case? If there is some environmental principle that could apply, and how would you be affected by the actions of the kingdom, and how could you use the environmental tools? So what would you ask the kingdom to change, and according to which international conventions?
Thanks everyone for joining.